It's an interesting question, and more often than looking at cases where other lawyers are not interested, we look at cases where other lawyers have been involved, yet have not necessarily done the best job of determining the client's full damages, of determining whether or not liability can actually be proved or not proved. As an example, I would give you two examples of clients who I have recently resolved cases for. The first was an individual who had suffered a shoulder injury in an automobile accident, and the lawyer that she had hired eventually wrote her a letter saying that she had not suffered a permanent injury, and that as a result of Florida's law that requires that you obtain a permanent injury before you can seek an award for pain and suffering, you have to suffer a permanent injury. The law firm was not incorrect in their terminology and in their instructions to their clients. However, what they had missed in the file was the fact that she had been diagnosed with a permanent injury. She had not been diagnosed with a permanent impairment rating, which are two completely different things. Once she had been terminated by her lawyer, fortunately, she sought other legal counsel, and she did not simply take their advice and not pursue her case. She eventually made her way to us, and we were able to fairly quickly settle her case simply by filing a lawsuit and pointing out the injuries that she had suffered, resolving her case for $250,000. So a lady who had been given the wrong advice in the wrong situation potentially had cost herself $250,000 worth of justice had she listened to that lawyer and not sought a second opinion. Another example that I would give you is a similar situation. Another one of the law firms who we all very familiar with, and we see their billboards up and down the highway, had told our client that they could not be of service because there was no way to prove that his injuries had been related to the accident. His lawyer was interested in talking him into a $25,000 settlement, which was the final, last, and best offer which had been put on the table by the insurance company. The client rightfully declined to accept a $25,000 settlement, as his case was worth far more. And at the point where he and his prior lawyer could not reach an agreement for his prior lawyer to take his case to trial, to give him a chance in front of a jury to obtain full justice, he hired our law firm. I took the case and handled the case through litigation and was able to settle the case at mediation for $300,000. Just another example of perhaps law firms that have gotten too big or too busy, or law firms who simply don't pay enough attention to their files, don't know enough about their clients, and don't know enough about their clients' cases to completely, adequately, and fully obtain justice for their clients.